Well, I want to thank everybody for coming today. And, you know, it's a pretty good crowd. So would all of you from the press raise your hand? Well, we got 1, 3, okay, 4. Well, it's a pretty good crowd from our office. And I think it's really important that all of you who are here see this. So when we hear the name Harvard University, most of us immediately associate that with a high degree of prestige and integrity. As the oldest institution of higher education in the country, established over 130 years ago, it's known for educating world leaders, Nobel laureates, and more. According to media reports, a newly formed group affiliated with Harvard Law School gave itself the auspicious name of Fair Punishment Project. They supposedly reviewed court decisions from 2010 to 2015 involving the Orange County District Attorney's Office. The study found that the Orange County District Attorney's Office had 7 convictions reversed due to prosecutorial misconduct and 24 overall findings of prosecutorial misconduct. And these numbers were ranked amongst the highest in the state. At first glance, those numbers were startling. But upon further inspection, there was just one problem. The numbers are completely wrong. Even when the group heard that they might be exposed for their errors, they still gave the wrong numbers in their correction, which is posted on their website. It was posted on Monday. Curiously, the authors did not show their work. The Orange County District Attorney's Office was not contacted before they published this so-called study. Let me start by saying that the Orange County District Attorney's prosecutors handle over 60,000 new cases during that study period, and that equates to well over 300,000 cases during that period. They dedicate their lives to making our office the best in the nation. Our multifaceted gang and prosecution prevention units, DNA units, human exploitation and trafficking unit, homicide units, fraud units, all of them, all of you, are second to none. Without a doubt, the Orange County District Attorney's Office will never stop looking for ways to improve, which is exactly why we wanted to delve into the numbers and verify that we're indeed the worst in the state, and if so, what we could do to make immediate changes to improve that situation. What's the truth? The information asserted by this group just does not match the evidence. As a prosecutor, you can imagine this is something that doesn't sit well with me. Sure, since the facts behind the numbers were conveniently left out of this academic study, I'm going to let Assistant District Attorney Ibrahim Beytai of the Special Prosecutions Unit show you some of what the real facts are. Ibrahim.
Good morning. I want to walk you through a little bit what we did in our office, and I want to start with the study itself, what they published and the information that we were able to review. So just as a background, Harvard Law School Fair Punishment Project published a report in July 13th, and the title of the report was The Recidivist, New Report on Rates of Prosecutorial Misconduct. This FPP was formed last year in 2016 as part of Harvard Law School's Criminal Justice Institute. The FPP specifically targeted our county, not after doing their analysis and not after doing their research and not after doing their numbers. They did that before. Before they did their analysis, before they reviewed the cases, before they reached any conclusion, they were targeting our office. And we know that because their spokesperson told us that. This is an interview by the spokesperson of this institute relating to their study. And she was asked specifically, why Orange County? Why are you targeting Orange County? That's the name of the lady. And she specifically said, we focused on Orange County because there's a lot of stuff in the news about the county. There's a lot of stuff in the news about the DA's office in Orange County. And this is an office where there are a lot of stuff happening. So they read newspaper articles and they reached a conclusion before they read a single case. Okay, so that's kind of where we start. They state in their study that they read every single published opinion from 2010 through 2015 relating to, they said they did it for the whole state, specifically relating to our county. Now, I use the term allegedly because when that, and by the way, That 2010, 2015, that's their self-imposed period. We had nothing to do with that. We didn't pick that period. We didn't suggest that period. They picked that period. They said, we want to evaluate the Orange County DA's office from 2010 to 2015. Fine. They said that, and I use the term allegedly because we know they did not do that. We know that because we take these type of issues very seriously in our office, regardless of what people want to say, regardless of how fashionable it is these days for people to want to take a shot at honest, decent prosecutors that do their job every day. We knew that they missed the case that we had caught. There was a case that was published during that same period of time relating to our office, relating to a closing argument by a prosecutor from our office. They didn't catch it. We were aware of it. We had taken a step regarding that case. They didn't catch it. So we realized from the beginning they're kind of missing something. So we decided that we're going to look at what they did and their analysis. This is their report regarding our county. They put different rankings, and this is the main one. We are the worst county based on their analysis and their study and the name of Harvard behind them. We are the worst county in California when it comes to reversals per capita based on prosecutorial misconduct. They set these parameters, not us. They said, we're going to look at cases where there is a finding or a case where the court found prosecutorial misconduct, and then there was a reversal because of that prosecutorial misconduct. Fine. If you kind of keep in mind, when they published this study, they didn't provide any raw data. You can read, it's online. You can go read the study. Doesn't mention a single case. Doesn't say what cases they read. Doesn't say what analysis they did. They just said, we looked at all the cases, all of them, all the published cases from 2010 to 2015. The rest of their study, they talk about the cry and other people and other cases in the news. That's not even within the time frame that they're supposed to be talking about. Okay, that's fine. Shortly after they published their study, there was a newspaper article in Orange County talking about the Harvard study, talking about Harvard Law School, talking about Harvard University. And that article in the paper references two numbers, 7 and 24. They said there were 7 cases during that period of time where the court did 2 things, found prosecutorial misconduct and reversed due to prosecutorial misconduct. The second number was 24 total cases where the court found prosecutorial misconduct and either reversed or did not reverse. So you just kind of do easy math. So there were 17 cases, they said, the court made a finding of misconduct by the prosecutor, but did not reverse. So that's kind of where we're starting. We wanted to look at it. Just give you an idea just about this period of time that they picked, right? So they were 7 and 17, 24 total cases. 7 cases where they said they found cases where the Court of Appeal found prosecutorial misconduct and reversed the conviction because of the prosecutorial misconduct, and 17 cases where the court found that there was misconduct by the prosecutor, but it was harmless error and they did not reverse. They didn't limit themselves to felonies. They just said every single case, felonies and misdemeanors. That's fine. That's their parameters, and we wanted to look at it. Just keep in mind, during that same exact period of time, our office filed 305,907 cases during that period of time. No problem. So we filed over 300,000 cases, and using 14 cases based on their analysis, they said we are the worst of the worst in the state of California. So here's the response to their report. Their report is published, and our local paper publishes an article about dozens of convictions tossed out of Southern California courts because of prosecutorial's bad behavior, Harvard study says. Then there is an editorial board published, and that editorial board say we are the worst in the state, right? They didn't just say that. They actually say these were not just cases of errors. They said that, and I'm going to talk to you about it a little bit more. They said these are cases where prosecutors were cheating, hiding evidence, fabricating evidence, going after innocent people. So we became, based on citing the study of Harvard, the worst county in the state when it comes to prosecutorial misconduct. These were their 2 main categories. Second most reversal due to prosecutorial misconduct, that makes us first per capita. So what they did for their per capita is they took the number of reversals for prosecutorial misconduct and they divided that number by the population of each county. And based on that analysis, we are the first per capita. And then they said, if you include everything, where cases the court reversed for prosecutorial misconduct or did not reverse but found prosecutorial misconduct, we are the 5th per capita. Okay? So we wanted to look at what they did. There was nothing to look at. Nothing. Harvard study, and if you look at it, a lot of their footnotes relate to local blogs and newspaper articles and magazines articles and Huffington Post. I'm trying to name the ones that come to mind. I'm pretty sure if I file a brief with the judge in court and I cite the Huffington Post, he or she is not going to look very favorably on my argument. But that was the citation for their study. We wanted to get that data. We wanted to look at it, not because we wanted to stand up here and say, Harvard is full of it, they didn't know what they were talking about. We did it because we wanted to learn what is it that we need to do better. If Harvard Law School, one of the best top educational institutions in the nation, is saying we did something wrong, I promise you the first reaction was not, they must be wrong. Our first reaction was, let's see what they're talking about. Let's see what we need to do to figure out what's going on. Fortunately, we were able to get their data. We weren't just able to get their data, we got their notes. We got their actual spreadsheets of the people from Harvard that worked on that study, including their notes as to each case they read, as to each opinion that they reviewed, and as to each case where they said, yep, in that case, the Court of Appeal found prosecutorial misconduct, and yes, in that case, the court reversed for prosecutorial misconduct. Remember, 7 cases. So here is what we had, 7 and 25. So that's their raw data. We are just looking at what they did. We're looking at their analysis. They had 7 cases with a yes for prosecutorial misconduct and yes for reversal, and 25 total for yes for prosecutorial misconduct, reversal or no reversal, it doesn't matter. Interestingly enough, remember I told you about that article that was published? Remember, there is no raw data. I can't go online and find that data. That article that was published talks about 7 and 24, where the raw data from Harvard says 7 and 25. I'm going to show you why they wrote 7 and 24, because right away when you look at that data, one of them is outside that period. One of the cases they relied on is from 2016. I want to take you back. That time period that they're talking about is not the date of the violation, is not the date of the trial, is not the date of the alleged misconduct by the prosecutor. It's the date that the Court of Appeal issued an opinion, published or not. So they went by January 1st, 2010 until December 31st, 2015. Every case that the Court of Appeal issued an opinion on, they said they studied. The reason the article talks about only 24 rather than 25, because one of those 25 cases, you don't even have to read it. You look at it, and the date of the opinion is 2016. So the reporter takes that case out. So the reporter writes 7 and 24. Okay. We're going to talk about what Harvard did, about their 7 and 25. We wanted to really look at that data to really figure out what is it that we need to do better. You know, we wanted to get that number of 7 to 0. If they're right, we want to work to do and get better. That was our objective in looking at the data. We looked at it from an objective standpoint in the conviction integrity function of the Orange County DA's office to try to figure out what is it that we need to do better. So, after getting their data, we pulled every single one of the cases they talked about. Every single case that fits into that category. Read the cases that they said there was reversal for prosecutorial misconduct, and read the cases that they said there was prosecutorial misconduct but no reversal. Every single one of them. So here's what we found out, which is the truth. There's nothing subjective about what I'm going to share with you right now. Absolutely nothing subjective. It's all Court of Appeals opinion. Anybody that has access to a computer can get those opinions. Remember, they talked about 7 cases. So keep in mind, we are now talking about their first category. 7 cases. They say there's finding of prosecutorial misconduct and a reversal due to that prosecutorial misconduct. This is when the Court of Appeal said, Mr. DA, Madam DA, what you did was misconduct, and because of what you did, we're going to reverse the conviction. There were 2 reversals for prosecutorial misconduct, both for improper argument at closing statements. Nothing about hiding evidence, nothing about fabricating evidence, nothing about hiding anything from the defense. It's about a DA during closing argument and arguing to a jury, making a statement during closing argument on the record that the Court of Appeal found objectionable to the point where they reversed the conviction. There were two cases that fit that criteria. The first one is the Lloyd case. The Lloyd case was an assault with a deadly weapon where the defendant was claiming self-defense. In closing argument, the Court of Appeal found that our prosecutor, in arguing against self-defense, equated the finding of not guilty with no crime being committed. The Court of Appeal said that was inappropriate argument. The Court of Appeal found prosecutorial misconduct. The Court of Appeal reversed. That case fits that criteria. Lloyd, first case. Second case, Ramirez. This is a gang member in possession of drugs for sale. The defendant was convicted. Again, closing argument. The defense was claiming that the police officer lied, and the prosecutor in closing argument made statement about why the jury should not find that the police officer lied. The Court of Appeal said that argument was inappropriate, and the Court of Appeal reversed the conviction. Actually, they reduced it. They reduced it from the defendant being convicted of possession for sale to being convicted of the lesser offense of simple possession. But nonetheless, the Court of Appeal said, we find the argument by the prosecutor legally objectionable, and we're going to reverse based on misconduct during that closing argument. Again, nothing about hiding evidence, nothing about fabricating evidence, nothing about going after innocent people. Two cases. Okay. If you're going to hold your breath to hear about the other 5 cases fitting this category, you got to start breathing, because you're not going to find any. That's it. That's it. Only 2 cases. Let me tell you about the other 5 cases that they concluded were reversed for prosecutorial misconduct. 2 of them were not even reversals, had nothing to do with our office, had nothing to do with conduct by our prosecutors. The first case was the Rezek case. It was a pitches motion. And most of the people in this room know what a pitches motion is, but for those of you that don't, this is when a defense attorney says, I don't care about the DA. I'm not asking the DA for anything. I'm going to the police department. I want to look at the personnel file of the police officer. We are not a party to that motion. The pitches motion is a motion between the defense attorney and the city attorney for that police agency. This case was from Tustin. It was a motion that the defense attorney filed wanting to get report from the personnel file of certain officers. Our DA did not get involved in it. We didn't take a position. We didn't object. The judge reviewed the personnel file, and the judge said, I am not going to give you anything based on the pitches motion. Has nothing to do with us. The defense took an appeal. The Court of Appeal said, the judge made a mistake on that pitches motion. The defendant should have received some documents from the personnel file of a police officer. They sent it back to the trial court. The defendant was tried and was convicted. There is nothing, absolutely categorically nothing about prosecutorial misconduct, let alone a reversal. That case counted as one of the cases they said we committed prosecutorial misconduct in. Here's what the court said in that case. The trial court abused its discretion in denying defendant's discovery motion on the mistaken belief Penal Code Section 1054.1 is the exclusive means by which a defendant may obtain such statement. The Court of Appeal made it very clear. Justice Moore made it very clear. The judge should have given the defense attorney information from the personnel file of the defendant. Has nothing to do with our office. They counted that as a case reversed for prosecutorial misconduct. The second case was a robbery case. Multiple individuals, gang members in Fullerton, they commit a robbery of a guy in a parking lot. They steal his necklace. One of the defendants, as he was arrested, he tells the Fullerton police officer, hey man, I had nothing to do with it. If you get the video cameras from the area, you'll find out that I had nothing to do with it. Defendants are charged. The first or second hearing in court, the defense attorney says, Your Honor, I would like the Fullerton PD to go and collect any videos from the scene from any businesses in the area. The DA says, Your Honor, I've already requested that. I even requested that the Fullerton PD brings me any videos they have of their own video cameras. Prelim is held. Defendant is held to answer. Fast forward a few weeks down the road. Fullerton PD has video cameras throughout their city that they maintain, the actual police department. But these video cameras, every 2 to 3 weeks, if you don't pull out the footage, they cannot record over it. By the time the defense attorney figured out I haven't received anything, Fullerton PD, not us, had nothing to do with prosecutorial misconduct. The Fullerton PD had erased the video, had taped over it. The defense filed a trombetta motion, and I know most everybody in the room know what that is, but for our friends here that don't know what it is, this is when a defense says, the police agency destroyed evidence that I was entitled to get, therefore I want a dismissal. Has nothing to do with our office, nothing. They had a motion before a trial judge, the trial judge agreed, and the trial judge dismissed the case. Not because of anything we did. The trial judge, as a matter of fact, during the hearing said, I believe the DA asked for that stuff. I believe the DA asked Fullerton PD for that information. They destroyed it, they didn't give it to the DA. The defendant gets the benefit of a dismissal. It goes up on appeal. And the issue on appeal was whether or not the judge was acting properly when he dismissed the case as to 3 defendants. The Court of Appeal ended up saying, as to 2 of them, he was correct. As to a 3rd defendant, the judge was wrong. The case should go back. That 3rd defendant should proceed. The case that they cited related to one of the defendants that was dismissed, Alvarez. So that's one of the defendants where the Court of Appeal said, yes, we agree with the trial judge. The Fullerton Police Department destroyed evidence that was supposed to be preserved. The court said that. This is in the Court of Appeal's opinion. This is not a secret. This is not the notes of Justice Moore. This is her opinion that was published by the Court of Appeal. The court believed it was likely that the prosecutor at the hearing in October 2012 had actually made a request to the Fullerton PD to preserve video, but it had not been acted upon. The Fullerton PD's conduct is as disturbing to us as it was to the trial court. The Fullerton PD's conduct. Yes, police officers and police agencies are part of our prosecution team. We're not talking about that. We're talking about findings of prosecutorial misconduct, where the actual prosecutor committed misconduct. None of that in this case. None. 0. They counted that case as one of the cases that was reversed for prosecutorial misconduct. There was no reversal, and there was no prosecutorial misconduct. Right? So now we talked about 4. There are 3 more cases. Every single one of those cases was reversed for a finding of judicial error. Had nothing to do with the DA. None. The first case is a baby death case, Choi, where a 9-month-old baby was murdered. And during the trial, the defense called an expert witness to testify about an opinion that the expert witness was going to give to say that the baby died as a result of a pre-existing disease or an illness. Our prosecutor, doing his job during the trial, whenever he felt that the question calls for either speculation or there was lack of foundation, made a proper legal objection in court. He was doing his job. This case was trialed in front of, at the time, probably one of our most experienced and senior judges. Judge Fazil was a trial judge. The judge sustained a lot of those objections. On appeal, they claimed a bunch of stuff, and they claimed the judge made a mistake by sustaining foundational objection to the testimony of the expert witness. They made other objections. They made other allegations. They alleged that the prosecutor, when he showed the jury in closing argument a picture of the victim, a picture that was admitted into evidence, that was misconduct. They made those allegations on appeal. The Court of Appeal said, we don't need to get to any of your other allegations. We agree that the judge sustained objection inappropriately. They felt that the expert witness should have been allowed by the court to testify. So they said that. As noted, because we reverse for other independent reasons, we need not decide in this opinion whether the prosecutor committed misconduct. They said that. Courts do that all the time. An issue becomes moot. There were 4 issues before the court. The court said, on the issue of the judge sustaining objection, we find that the judge made a mistake. We're going to reverse. This case was counted as a case that was reversed due to prosecutorial misconduct. That's absolutely categorically not true. Second case, even more blatant than that. In this case, there were 2 individuals, a juvenile and an adult, they stole a car and they were in a stolen car. The juvenile went to juvenile court to be adjudicated as a minor, and the adult was being tried in North Court as an adult. During the trial of the adult, the adult defendant wanted to introduce evidence from the juvenile record of the co-defendant. Everybody knows in California, you can't just take a juvenile file and just have people look at it. It has to go through a judge. The judge held a hearing. The judge reviewed the juvenile file, and the judge said to the defense attorney, there is nothing here that you're entitled to receive. The defendant gets convicted. On appeal, the court says, the judge made a mistake. The judge should have given the defense attorney part of the guilty plea of the juvenile. The judge said the juvenile was, the defendant, the adult defendant was entitled to receive, this is the appellate court, was entitled to receive information from the juvenile file. The justices, when they wrote their opinion, because that deals with the aspect of Brady, but their entitlement to information that assists in their due process right to get a fair trial, the Court of Appeal didn't have to do that. You know what the Court of Appeal wrote in this opinion? Because they wanted to make sure nobody reads the opinion and goes, oh, that was the fault of the DA. That's what they said. We do not find fault with the prosecution because it acted on the direction of the court, and we find nothing in the record to even suggest that the prosecution urged the court to withhold this evidence from defendant. But the result was the same and requires a reversal of the unlawful driving charge. They made it as clear as the sun that there was no prosecutorial misconduct, and the reason why they're reversing had nothing to do with the prosecutor. That's their language. This case becomes one of the 7 cases that the smart people up in Harvard decided qualifies as a reversal due to prosecutorial misconduct. Last case involved one of those catch-a-predator case. You know, Craigslist, a sexual predator gets on and he thinks he's talking to a minor, he's talking to an undercover cop. It goes to trial, the defendant gets convicted. During the trial, the defense asked for an entrapment instruction. They said, hey, judge, our client was entrapped by the police officer. We would like you to instruct on entrapment. The trial judge said, I don't believe there is sufficient evidence to give that instruction. I'm going to deny your request. It went up on appeal. The Court of Appeal said, the judge made a mistake. The judge should have instructed the jury on entrapment. Therefore, we are going to reverse as to that one count. The court made it, because we reverse for a new trial on this ground, we need not reach the defendant's other contention of error. Court said, we are reversing based on instructional error. The judge gave the wrong instruction to the jury. We're not going to reach any of the other alleged error. One of the other alleged error was that the prosecutor committed misconduct because he caught the defendant with a lie on the stand. The trial judge had made a finding, the defendant lied, and the prosecutor caught him with a lie. The Court of Appeal said, we're not even going to get to that. It's moot, we're not making a finding. This case becomes, in the Harvard study, as a case where the court made a finding of prosecutorial misconduct and reversed the case due to that finding. They're absolutely categorically wrong. But that's the beauty of the truth, is that the truth comes out. Because remember I told you we have access to their notes? I'm going to show you what they wrote in their notes. The brilliantly smart, wonderful, amazing people up in Harvard, what they wrote in their notes about this case. This is in their raw data and their notes. Brady issue not reached, but law enforcement may have entrapped the defendant, meaning the prosecution itself may have been a product of misconduct. So may have, and may have, and may have. The test is never, ever may have. And by the way, even if the test was may have, it still doesn't fit. This has nothing to do with prosecutorial misconduct. This is them saying, you know, when the cops was talking to this defendant, pretending to be a 13-year-old, he was really getting him, you know, he was entrapping him. Has nothing to do with prosecutorial misconduct. They knew that. That's their notes. We didn't write that. They wrote that. They still counted this as a case where a finding of prosecutorial misconduct was made and that the Court of Appeal reversed for that finding. And then people eager to grab on anything that points the finger at our office, we're happy to print editorial boards and all kind of stuff, the worst office in the state. They're wrong. They're absolutely, categorically wrong. So this is the report, right? This is what the editorial board writes. They don't write, maybe they made mistakes in closing arguments. Remember, they have access to that data because they wrote that in their article. Here is what they write. These are not cases of errors, but of willful and serious misconduct, which can include the use of fabricated evidence, introduction of false testimony, and withholding of evidence that points to innocence. So that's what they wrote. Willful, serious misconduct, fabricated evidence, false testimony, withholding of evidence. None of that is true, none of it. But we have the law on our side, because this is what people on the editorial board want to write. But let me show you what the law says and reality says about the areas of misconduct that they're talking about. The term prosecutorial misconduct is somewhat of a misnomer to the extent that it suggests a prosecutor must act with a culpable state of mind. A more apt description of the transgression is prosecutorial error. This is the California Supreme Court, and we picked a case that was smack in the middle of their review period, 2014 case. And I'm going to tell you why this case becomes even more important. Remember those two cases that fit their criteria of reversal due to prosecutorial misconduct? They were both about closing argument by the prosecutor. This Centeno case is about closing argument by the prosecutor. In the Centeno case, this is a San Bernardino case, the prosecutor got up and trying to explain reasonable doubt to the jury, put up a map of California that wasn't actually correct, and started talking about, well, some people can come and testify about California, and they can be wrong a little bit, but even though they're wrong, it is reasonable that they're talking about the state of California. The Court of Appeal says that's not a proper argument to make. But when it comes to argument being made to the jury, that's how the Supreme Court defined it. A more apt description of the transgression is prosecutorial error. And it turns into willful and serious misconduct that include fabrication evidence. We are fabricating evidence. They take that study that's faulty. Anybody that has a common sense and the ability to read will be able to tell that it's faulty. Remember those other 25 cases that I told you about, that they talked about? One case was in 2016. Remember that discrepancy between 7 and 24 and 7 and 25? That's where that discrepancy is. Because one of them, clear, you don't have to read it. It takes 5 seconds to say, wait, that's a 2016 case. It doesn't fit into your time frame. So you take that case out. There were 3 cases where there was actually no finding of misconduct. None. Remember, now we're talking about cases where they said there was misconduct, but the court said it's a harmless error. There was none. Here are the 3 cases. Even were we to find the statement have been an appeal to the sympathies of passion or the jury, because we find defendant failed to demonstrate misconduct. That's one of the cases they said, in that case, the court found prosecutorial misconduct but didn't reverse. That's not what the court said. That's not what the court said. Here's the other case. We conclude only one of the challenged questions or arguments was potentially misconduct, might have been misconduct, because the trial court immediately admonished the jury after the argument was made. So courts do that all the time. Even if it was, it doesn't make a difference. They didn't make a finding that it was. They know how to make such a finding. The Court of Appeal, and they do it in cases. No such a finding was made in the case, and this case was counted as a case where the Court of Appeal made a finding of prosecutorial misconduct. The third one was the People versus Sanders case. The court says, at most, arguably committed misconduct. However, the explanation shows there was no misconduct. This is where the DA in closing argument was saying, here's what the expert relied upon, and the defense says, hey, that didn't come in for the truth of the matter. That came in as the foundation of the expert's opinion, and the DA in closing argument made it sound like it came in for the truth. The Court of Appeal said no. Challenge statements were an explanation of the basis for Gutierrez's opinion, and we inferred the jury understood them as such. This is like somebody going to their boss and going, hey, boss, I know I have an assignment that was due yesterday, and I'm really sorry I didn't give it to you because my kid was sick yesterday. And the boss says, well, even if your kid was sick yesterday, this assignment was due 3 weeks ago. Right? That's what the court is saying. Even if they were, doesn't matter. That turns into the Harvard study as a finding of prosecutorial misconduct by the Court of Appeal. Now, you notice the thread about kind of the pattern. They're all, no cases about fabricating evidence. We're not talking about cases where people are hiding evidence. We're talking about cases where the court said the argument that you made in closing argument stepped over the line. We're not suggesting that's okay. We're not suggesting we should do that. We should not. And we get trained, all of us, not to do that. But just to put it in context, this is not fabrication of evidence, planting evidence, lying about evidence. Here's what the court said in some of these cases. A single brief portion of the prosecutor's closing, an isolated departure in a few stray words and not the focus of argument, buried in the middle of the prosecutor's closing argument, consisted of a single sentence, very brief and indeed half a sentence after defendant's objection, a single improper question in the course of a lengthy trial, a single isolated transgression, a rather minor digression. These are all things we should not do, and we should get trained on getting better, and we are. But the court said, this is just a minor issue in closing argument. Don't do it, it's misconduct. No problem. But this becomes actually, they said these were not errors. These were fabrication and hiding evidence and going after innocent people. So remember what I showed you before? They said we are the worst in the state because of 7 cases. Let's use the real number, 2. We become the 16th per capita if you count all 58 states. But if you count, because per capita is important, there are counties in this state that have 23,000 people, 25,000 people. A lot of the counties have less than 100,000 people. We have over 3 million people that live in our county. So if you count counties with 1 million and more population, we are the second best. We are the second best. The first best is Contra Costa. And we are the second best in the county. As to their second category, we actually become the 5th, rather than what they said that we had 25, there's only 18. That's the truth. Not subjectively, not us as prosecutors trying to kind of twist it to make it look. No, this is what the Court of Appeal said. So if you look at the correct ranking, this is where we become here. This is for cases where the court found prosecutorial misconduct and reversed. We are the second best in California in that category during that period of time. And these were the total finding of prosecutorial misconduct. The other danger in trying to play with numbers the way they did is, notice, for example, the county that is number 1 in both category, Del Norte. They have 23,000 people that live in their county. Because of one case, they become the worst in both categories. You know what happened if you take that one case away? They become the best in both categories in the state. So they go from the worst in the state to the best in the state because of one case. That's why if you want to look at the study, you got to look at it, you got to be objective. They were not up there in Harvard. You got to be intellectually honest on how you read cases. They were not. They were not. Now, oops, we made a mistake. Last week, we started talking to you. We told you, we got our hand on their raw data. They knew that we were going to respond to their study. Monday, on September 11th, they published 1-page revision. Go fine. You know, everybody makes mistakes. We're all for people saying, I made a mistake. But let's look at, it's very interesting that that revision only deals with Orange County. It's also interesting that they were able to find a bunch of stuff right away. Well, it's not interesting. It's their notes. We showed you their notes. So they issued the study and the revision on Monday, and here's what they say. By the way, do you think they picked up the phone in July before they published that study and say, hey, Mr. Orange County DA's office, we're publishing a study, we're reaching conclusions about your office. Here are 7 cases that we found that you guys messed up, and there was misconduct and reversal. Because it would have taken us half an hour, maybe 45 minutes, because they're up in Boston, so it's going to take some time, to show them how they're wrong on their study and their analysis. But they didn't do that. They published this in September, and they say, it came to our attention that an extremely small percentage were either incorrectly categorized, or the county was previously unknown, but has now been identified, or they were close calls that could have gone either way. They always knew the counties. But it's very interesting because they use the term extremely small percentage, right? Extremely small. So like if I go home tonight and I tell my wife, my boss says I'm going to have a pay cut, it's going to be an extremely small percentage pay cut. We're going to be okay, honey. It's an extremely small percentage. Their extremely small percentage is 71%. So that's me going to my wife, it's really an extremely small pay cut. It's just 71% of my pay is gone. 71%. 5 of their 7 cases were flat out wrong. By the way, you go, did they correct all of them? No. No, they only corrected 3. They said, oh, we made 3. So their 7 becomes 4. And by the way, if you don't like my 71%, even by their own analysis, they were 43% wrong. So, I don't know, maybe they can walk next door to where they teach Math 101 up in Harvard and ask somebody, is 71% or 43% an extremely small percentage? And I'm really not trying to be funny, but it's dangerous because they use that conclusion to smear the integrity and the hard work of people that wake up every day, not to do anything other than doing the right thing, every day. They use that, and they call that, they have the audacity to say, we made a mistake. By their calculation, 43%. They increased what they call our misconduct by 43%. They call that an extremely small percentage, and it's not 43, it's 71%. They were wrong 5 out of 7 times. They said something else very interesting, right? They say, well, this report in question sought to quantify an issue, prosecutorial misconduct, that has no singular definition. And you tell that to a lawyer or to a prosecutor, and they will laugh. Say, what do you mean there is no definition? There is a definition for prosecutorial misconduct. Every single case that deals with that issue gives the definition. This is not a philosophical discussion. This is not people talking about, well, in general, a prosecutor can commit. No, we're talking about specific cases and specific fact pattern. There is no dispute. There is no gray area about the definition. People can have gray area about does it fit. But the law is clear about what qualifies, what is the definition of misconduct. In every single case. Every single case. And I know the lawyers know that, but look at it. If you're a reporter and you're interested in being honest how you report this to the people that read or listen to your publication or your organization, read it. This is all available online. In every single case, before they talk about the facts, the court says, here is the definition of prosecutorial misconduct. Now, having said that, remember this, we do not find fault with the prosecution. Well, I really don't care what definition you use. You can use any definition on any planet. We do not find fault with the prosecution can never, ever be interpreted as reversal due to prosecutorial misconduct. It's just not true. By the way, this case is still on their study, on their website, as one of the cases that qualifies as prosecutorial misconduct. I'm going to tell you why. They really don't understand the law. Now, it's surreal to say that people from Harvard don't understand the law. The people that worked on this study most certainly did not. And I'm going to show you as we talk just a little bit more about this case. So this is the initial report that they published in July. So this is the July publication. We are the worst of the worst. Now, on Monday, when they knew we were going to do what we're doing right now, they issue this. They go, well, you're not the worst of the worst anymore. You're now number 4 out of the 58 counties. Right? Let's look at their numbers to see if they're right, because they are wrong again. Right? So this is their calculation, not ours, theirs. After they tried to fix their mistakes, it goes from 7 to 4. Well, the problem with that is those 4s are not right. And we talked about that already. Those 2 are already there, the same ones. This case, where it had nothing to do with our office, dealing with Fullerton PD, they still count that one as reversal due to prosecutorial misconduct. Still there, right? I read that to you earlier. How about this case? The one where the judge looked at the juvenile record and said there is nothing that I need to give to the defense, and he was wrong. Had nothing to do with our office. Where the court said, we do not find fault with the prosecution. They still, even after they made their revision, they still count this case as reversed due to prosecutorial misconduct. You know why? Because they don't understand the law. They don't realize that when you're dealing with the juvenile records, the DA has to go to the court. It's a requirement by law. What they don't understand also is that the California Supreme Court and the US Supreme Court has repeatedly said the duty of the prosecutor when it comes to Brady information is satisfied when the prosecutor takes the information and gives it to the judge for the judge to make a decision. We had the J.E. case involving a juvenile out of San Diego that said exactly that. a few years ago. And the Agers case from the US Supreme Court that said exactly that. They still counted this because they go, oh, this was a case where the defendant did not get something he was supposed to get. Therefore, it has to be the prosecution's fault, and it has to be prosecutorial misconduct. And they are categorically wrong. So that's their numbers in context, if you want to look at their numbers. During that period of time, based on their analysis, based on their own notes and their own raw data, there were 140 cases out of the 158 where the defendant said there was allegation of prosecutorial misconduct, and the Court of Appeal said no. And 89% of the time when a defendant said the DA committed misconduct, the Court of Appeal said no. 16 out of the 18 cases where the court found misconduct, the court said it's harmless. I read to you those sentences. One sentence in the middle of closing argument. Half a sentence before the defendant objected. They're all during closing arguments. And here is the big one. 156 out of 158 cases where the defendant said, I did not get a fair trial because the prosecutor committed misconduct. This is what the editorial board talked about, that there were fabrication of evidence and innocent people. 99% of the time, the Court of Appeal said no. Now, by the way, I'm not suggesting that one is okay, because our goal is this. This is our goal. We are at 99%, but we want to be at 100%. But if that means you expect prosecutors to be perfect all the time, you're forgetting that prosecutors are human beings. We make mistakes sometimes. We learn from our mistakes. We get better at it. So it's okay for you to say we would like you to be at 100%, but don't turn around and tell the good people of this county that we are fabricating evidence and we are withholding evidence and we are hiding evidence during that period of time that they're talking about, where the cases are available for anybody and everybody to review, because we're not at 100%. It's just not fair. It's just not right. And when people, I think if people step back and say, you know what the danger of that? It creates a mechanism for people to be able to say, oh, look at all the bad stuff they're doing, when the fact does not support it. That's the reality. The public is being misled based on this study that's using the name of Harvard Law School to give it credibility that it does not deserve. It's given it credibility that objectively, reasonably, it does not deserve. And those that want to continue and run around and call our office worst record in the state, it's just not fair. And for people that want to repeat it without looking into it, think about your best friend and your next door neighbor and your kid's teacher who may be a victim in a case, and a prosecutor who comes to work in the morning is handling that case. Do you want that case to be handled and people to say, I don't care about the facts, I don't care about the law, I don't care about what happened to the victims in this case. This is the Orange County DA's office. They're the worst record in the state. That's not true. We have a record that we are proud of. Do we make mistakes? Yes. Do we work on fixing our mistakes? Yes. But what this study published and the conclusions that they reached are demonstrably false. And we can show that because the facts and the law show that as clear as the sun. Thank you, Tony.
So I'm listening to Brahim give a statement, and it's a great job, very complete. I think it's a good statement, but I disagree. There's one point that I disagree on, and that is about the Harvard Law School people not understanding the law. I mean, come on, this is Harvard Law School. I think they do understand the law, and the numbers just don't add up. 5 of the 7 appellate decisions relied upon contain no finding of prosecutorial misconduct, as just previously explained, including one where it's opposite. It says, we do not find fault with the prosecution. 2 of the 7 cases were not even reversals, but they were legal motions. 3 of the cases were reversed based on judicial error, which I find to be interesting. There are more cases reversed based on judicial error than on any kind of conduct by the prosecutor. But we don't have the press, or we don't have a bunch of people saying, well, the judges are in a conspiracy to commit error and to violate the rights of individuals. No. 150 cases studied by Harvard, by the Harvard Law School, by this Harvard study. 99% of the time, the Court of Appeal disagreed with the defendant when the defendant said, hey, I didn't get a fair trial because of prosecutorial misconduct. Besides Harvard, there are several other esteemed individuals and groups that are associated with this fair punishment project. So we have to ask, did they review and analyze the raw data before aligning themselves with this poorly constructed project? In their own raw notes, the group admits that they sought to go after our office, which is obvious, because how else can you explain them citing such things as tabloid articles and news, short news broadcasts as facts, using those as facts to support their statements. So I encourage all of you here, all the people in our office and all of the people in the news who are here, to go through the raw data, go through the notes. And you know, if you need to take some time to think about it, to interview, to look at this and to analyze it, please feel free, because this is completely wrong. No scientific study, no law school or no other institution of higher learning should ever publish a report like this and call it a study. You know, it's puzzling how a respected institution like Harvard could allow its name to put its imprimatur on this study, and when it's such an unscholarly work. And then, of course, the media parrots that for whatever their reasons are, but particularly because it's Harvard. And, you know, a politician would jumps on that. A politician who covets this office, by the way, jumps on that and immediately starts saying this is the worst DA's office in the state. Ridiculous. Sometimes when an institution is embarrassed, they can become very defensive. They can get blindly defensive, for sure. And we hope this is not the case here, and that we're going to call on Harvard University to do the right thing and to retract this statement, to retract this so-called study, and you know, tell us something about what must have happened here. The motto of Harvard is Veritas, which means truth in Latin. And as you can see, they were far from the mark. We have an open letter to Harvard that we're sending out, and this presents the facts in pretty concise form, and we're going to have them get that right away. We've learned through this process that some members of the press actually did have the raw data, and so for whatever their reasons are, they still printed the articles the way they were. The prosecutors of the district attorney's office, the Orange County District Attorney's Office, call on those news agencies to write factually correct articles and to publish the op-ed. We're sending an op-ed piece, and we're sending this out not just to one newspaper, but we're sending it out widely. And we call on the news agencies to publish that and make these corrections. This kind of stuff does a lot of damage, and it'll be interesting, and certainly it'll be important to see that the press corrects these statements to try to undo that damage, to see if that's possible. And to that politician who jumped on this study and used it to try to enrich his political agenda, our prosecutors call on him to publicly retract those statements and to make the same corrections that we're asking the media to make. It's one thing to attack me, an elected official, and I don't like it that much, but it's one thing to attack me. I volunteered for the job, and it's to attack me for political gain, but it's not okay to attack our prosecutors or people who are working day in and day out and giving their all and dedicating their lives to fairness, to prosecution, to keep the people safe, and to do justice. Another thing that we should never forget, and that is that no matter whose fault it was that a case was reversed, we need to remember that crime victims and crime survivors are the people who suffer. At the Orange County District Attorney's Office, we know that we have a huge responsibility to carry out justice in an honest and ethical manner, and will continue to live up to that responsibility. But as you can see, none of the cases involve our prosecutors intentionally violating defendants' rights. None of them. None of them involve our prosecutors cheating or doing anything improper to try to get a conviction. Ultimately, I want to close with a reminder that scholars, reporters, politicians also have their respective responsibilities to seek the truth. And it's my hope that they'll take that responsibility, their responsibility to seek the truth, as seriously as we take ours. This concludes the formal portion of our press conference, and we're going to take questions. But before we take questions, I wanted to point out that we're recording the question and answer period for social media. So before asking any questions, please identify yourself by name and news agency, and we can proceed.
You said this did damage to the office. Can you quantify that? What type of damage are you talking about?
It's damaging to not just the office, but to the whole criminal justice system to send out reports, to send out false reports to the effect that the prosecution is cheating, is committing misconduct, and is doing these kind of things in order to get convictions. And the damage is that it tends to reduce the understanding that people have of the honesty and the fairness that we're working with to seek justice here. That we're doing what we can to honestly and fairly seek justice for the people. That we deliver hard blows that are fair.
And to follow up, how much time, money, and resources were spent into disputing this report?
Well, truth is, I really wouldn't be able to tell you that. That you're asking how much time was spent on reviewing all this and coming to the conclusion we came to.
Number of personnel assigned to it, yeah.
So I'll ask Raheem to tell you that.
So in our office, we have a conviction integrity function. We have different prosecutors that work on this conviction integrity function. On this specific project, we had 3 people, including myself, that were working on this project. They were all PA employees that were working on it. I can't, we're not like a private firm. We don't sit down and log in our hours as to each project. But this came out in July. We started looking into it sometime towards the end of July. It took us some time to get the raw data, so the majority of the work we had to wait until we got the raw data. But there were 3 people that worked on it. We worked on it hard. This was important for us because the objective, like I mentioned, was from the beginning, is not for us to be talking to you about Harvard being wrong. It's for us to try to figure out what is it that we need to do to learn from it and get better.
Thank you.
Yes.
Paul Anderson, City News Service. What I wanted to ask you about, though, is the appellate court ruling in Decry cited institutionalized corruption in multiple cases that stemmed from the Black Flag and other operations as buttressing that in the Decry in Gopal's opinion, upholding Gopal's ruling in the Decry case, to dismiss your office from prosecuting him. So that in that one opinion, they talk about institutionalized outrageous governmental misconduct, not necessarily prosecutorial misconduct, but also relating to police agency work and that sort of thing.
Well, we've been telling you and any other news person who would listen that those statements are completely untrue, and this is really not the time to go into detail on that. I'd be very happy to go into great detail with you. If you wanted to schedule an appointment, we could sit down and we could go through all of it, line by line.
But just to follow up, your office, when this all started to begin, there were a few notable murder cases, in fact, where Brady violations were alleged, in particular due to that one prosecutor. And you basically worked out deals with them, and I think ostensibly it was because you felt, or came to the conclusion that there was.
Right, and I think that
Right.
and I think that the reports on that, the results, the statements about cases unraveling were highly exaggerated. And I'd be more than happy to sit down with you and to go over that and tell you why we believe that.
But you still.
We'll make an appointment to do that.
Right, yeah, sure, but you still made plea deals in those cases. You're saying they were highly exaggerated claims.
We'll argue that in another setting.
Okay.
I'll be happy to. All right, ladies and gentlemen, thank you so much for coming. Appreciate your time and your attention. Thank you.